Afternoon, everyone. Welcome to this lunchtime talk. My name is Asha Kaushal, and I'm the Associate Dean Research and International here at Allard Law. Before we started our program, I wanted to acknowledge that UBC Vancouver campus is located on the ancestral unceded territory of the Musqueam people. I would also like to acknowledge, because we are running this lunch as a webinar, that you may be joining us today from many other places near and far, and to acknowledge the traditional owners and caretakers of those lands. Before we begin, just a few housekeeping items. If you have any technical difficulties on the webinar, please reach out via Zoom chat and be sure to direct your question to the host. If you have any questions for the speaker, we'll have a discussion period at the end. Please enter your questions into the question and answer box and not the chat. On to the Walter S. Owen Chair. The Walter S. Owen Chair in Law was the law school's first endowed chair, established in 1982 in honor of alumnus, the Honorable Walter S. Owen, and his many contributions to the legal profession and the legal community. The lecture is a public expression of the law school's wish to commemorate Mr. Owen and to thank members of the legal profession and community whose contributions the chair enabled the chair to be endowed. The chair since 1982 has been occupied by several distinguished and internationally recognized scholars and jurists who have contributed greatly to the scholarly life of Allard while they were here. We extend our sincere gratitude for the establishment of this fund, which has enabled the establishment of the Owen Professor and continues to support the Allard School of Law. I am delighted today to welcome Professor Laverne Jacobs to Allard Law as our Owen Chair for 2025. Many of you will know Dr. Jacobs as a tireless disability rights expert. She is the Research Chair in Disability and Administrative Justice at the Windsor Law School, where she has been on faculty since 2007. In 2022, Dr. Jacobs made history as the first elected member from Canada of the UN Committee on the Rights of Persons with Disabilities. On the committee, she chairs the Working Group on Communications and Inquiries, serves as committee rapporteur, and sits on the Working Group on Women and Girls. In addition to her work in Geneva, she is the director of the Law, Disability, and Social Change Project at Windsor Law School and co-director of the Disability Rights Working Group at Berkeley Law's Center for Comparative Equality and Anti-Discrimination Law. I first met Laverne a few years ago at the RDS workshop at Windsor Law School. The workshop marked the 25th anniversary of the RDS case, in which Judge Sparks was accused of bias for her observation about police conduct towards Black youth and the prevalent attitude of the day. Laverne wasn't contributing a paper to the special issue, but she nonetheless made a point of attending. She came to hear from others, many of them junior scholars, to welcome all of us to Windsor and to support her colleagues hosting it. This captures Laverne's generous spirit so well, and I'm so happy to have the opportunity to welcome her back here to Allard Law to talk about disability equality as an ethical project of inclusion. Please join me in welcoming Dr. Laverne Jacobs.
All right, well, good afternoon, everyone, and thank you. Thank you, Asher, for the very, very warm welcome and the kind introduction. I'm grateful to be joining you on the unceded territory of the Coast Salish peoples, including the territories of the Musqueam Awesome, the Squamish, and the Waitut Nations, Tsleil-Waututh Nations. I'm very pleased to spend time with you as a visitor on this land. It's definitely a sincere honor to be delivering this year's Walter S. Owen Lecture. As has been mentioned, among his many distinguished achievements, Walter Owen was the president of the Canadian Bar Association in 1958. He was also a prominent lawyer, philanthropist, and businessman, and most notably, the 22nd Lieutenant Governor General of British Columbia. It's a privilege to be the visiting lecturer under the endowed chair that carries his name. And I thank Allard Law for the opportunity to have me share my thoughts in this context this afternoon. What I will be discussing today in my lecture is why efforts to achieve disability equality through the law meet with varying levels of success, and how we might improve this situation. To be more specific, there's definitely a rich history of legal decisions and legislative developments that have occurred over the past 50 years. This timeframe includes some of the most significant cases brought by advocates in disability rights law in Canada, and some of the boldest efforts to achieve equality for persons with disabilities. Some of these efforts have been made by the federal, provincial, and municipal governments. Nevertheless, disabled people continue to face significant barriers to equality, and I argue that there may be ways to refine approaches in order to improve the prospects for achieving deep and meaningful social inclusion for persons with disabilities. Moreover, cognizant that too often, in the case of persons with disabilities, interacting identities result in increased marginalization, I believe that any avenues that are taken to improve equity, equality, and social inclusion must not only keep this intersectional component in mind, but ensure that there are viable ways to address it. And so I think that that is kind of an important grounding to start from. So in this lecture, I'll set out the concept of disability equality first, drawing on international disability rights law as found in the UN Convention on the Rights of Persons with Disabilities. I'll then discuss the results of studies that I've conducted in two socioeconomic contexts. These contexts are transportation and post-secondary education. In these contexts, different legal mechanisms have been used to help ensure equality rights for persons with disabilities. I'll move on from there to describe a conceptual approach that I've termed disability equality as an ethical project of inclusion, and explore briefly what this conceptual approach may have to offer in terms of advancing disability equality and the ways that this might be done. But first, let me start with a few words about my own experience of disability and legal scholarship by way of introduction. When I was a law student, I was not a disabled person. I became a wheelchair user later, after I had been called to the bar and was completing my PhD. My disability was caused by a spinal cord injury, and as these things go, it changed my world and the way that I would function in this world considerably and within a short space of time. As a legal scholar, I had been interested in the administrative justice system at the time of my injury. I had already been researching and writing in this area of law. And my new realities prompted me to examine the use of the administrative justice system by persons with disabilities. Indeed, persons with disabilities make up a large proportion of those that use the administrative justice system regularly. This is because disability discrimination claims, social benefits, workers' compensation, these are all issues, along with the regulation through adjudication of various disputes. These are all issues that a large proportion of persons with disabilities face on a daily basis. I'm happy to share with you the snapshot of who I am and why I'm interested in issues relating to persons with disability. In doing so, I have no intention to be dramatic or to use this opportunity to engage in what's often called inspiration porn. So the idea that there are, persons with disabilities are there to inspire others without disabilities to achieve certain things. My intention rather is to show how personal circumstances can provide a different perspective on the issues that we encounter, and in the case of academics, in the issues that we study. After my spinal cord injury occurred, I engaged more frequently with other members of the disability community. And I began to really recognize some of the structural issues that we were facing. Some of these structural and systemic barriers were faced as a result of things such as disregard for architectural needs, the absence of quiet spaces, the absence of supports for those of us who were parents, for example. But at other times, these disability barriers were compounded as they stemmed not only from issues relating to lack of foresight, but were compounded by additional issues relating to other elements of identity, such as gender, indigeneity, migration status, etc. Overall, I've always had an interest in understanding lived experiences in order to improve the law and legal systems. And as I became more and more engaged with disability issues, I paid more attention to the experiences of persons with disabilities in my work as a law professor, concentrating on the moments where persons with disabilities experience inequality, and seeking to improve concepts such as access to justice, fairness, and equality so that they're better able to speak to the experiences of disabled people. So as you know, our work as law professors extends beyond research and teaching, both inside and outside of the university, and extends to opportunities such as those that we engage in service and to the community. Over the course of my career, these opportunities have offered me the chance to reflect and act through initiatives to improve disability, equality, and inclusion. Currently, I have the honor of serving on the United Nations Committee on the Rights of Persons with Disabilities, and this is the human rights treaty body that's responsible for implementing the Convention on the Rights of Persons with Disabilities around the world. There are over 190 countries that have ratified the convention, the CRPD as it's commonly known, making it the largest ratified human rights treaty after the Convention on the Rights of the Child. The work of the CRPD committee incorporates both a policymaking and an adjudicative role. The committee performs both types of function. In its policymaking activities, the committee provides recommendations to countries on implementing disability rights. In its adjudicative, and this is often done through country reviews, in its adjudicative capacity, the committee renders decisions on individual complaints or communications against states parties. From my experience, I would say that the convention itself is a tool with significant potential. Under Articles 35 and 36, for example, and through constructive dialogues, states parties report to the committee on the steps that they've taken to fulfill their treaty obligations to persons with disabilities. Concluding observations detail specific tasks that the countries should complete. And the optional protocol to the convention also allows for individuals to bring cases to the committee. A lesser known but powerful tool of the convention is the optional protocol's inquiry function. This inquiry function can be used to ask the committee to investigate potential systemic violations of the rights of persons with disabilities with follow-up. Organizations of persons with disabilities use the outcomes of the CRPD committee in their efforts to hold their governments to account. NGOs also provide helpful shadow reports at the time of the country's periodic reviews to outline strengths and gaps in government achievements. By far, though, I think that the most effective tools of the human rights treaty bodies is their ability to develop norms that can be applied across the board, across the world, in domestic law and policy, and fleshing out the central ideas and concepts that underlie equality and non-discrimination is one area where the CRPD committee has provided significant guidance. So let me share a few foundational ideas about the concept of disability equality from what they have put out. We'll get this. Okay, thank you. Oh, that's perfect, thanks. Okay, so what is disability equality? Most of the ideas relating to disability equality can be found in the CRPD committee's general comment number 6 relating to Article 5 on equality and non-discrimination, and can also be found in the convention itself. Disability equality is based on 2 pillars. The first is the human rights model of disability, and the second is the inclusive model of equality. General comment number 6 provides us with guidance on both of these pillars. With respect to the human rights model of disability, it emphasizes the human dignity of persons with disabilities. It starts from the premise that disability is a social construct that arises from the interaction between an individual with impairments and barriers that they encounter in the environment. The CRPD committee is very clear in indicating that impairments can't be the basis for denial or restriction of human rights. In this way, the human rights model shares the foundational principles of the social model of disability, which also deals with barriers and the elimination of barriers in society for persons with disabilities. The human rights model goes on to embrace human variation and sees impairment as part of human variation. This is a unique and novel approach that's been brought forward. The complexity and politics of identity, including intersectional identity, are also recognized through the human rights model of disability. Finally, the human rights model of disability encompasses values that can further social change, such as respect for the autonomy, independence, and full inclusion of persons with disabilities. And you can find these values within the actual convention itself, where it lays out 8 underlying principles of the convention. The human rights model of disability is often said to provide a roadmap for change, a roadmap for social change. And it goes beyond simply describing disability as the social model does, and actually considers, or at least provides some elements for consideration in terms of how we may actually engender social change. In addition to the human rights model of disability, the committee has also provided us with the inclusive model of equality, which is also outlined in general comment number 6. A central component of inclusive equality is the rejection of formal equality and a focus on substantive equality. In the context of substantive equality, the committee discusses attempting to address structural and systemic discrimination and paying attention to power relations as part of doing that. Moreover, inclusive equality involves taking into consideration 4 dimensions of equality. And as the committee explains, these 4 dimensions are a fair and redistributive dimension to address socioeconomic disadvantage, recognition dimension to combat stigma, stereotyping, prejudice, and violence, and to recognize the dignity of human beings and their intersectionality. A participative dimension, which reaffirms the social nature of people as members of social groups, and an accommodating dimension to make space for difference as a matter of human dignity. So overall, pursuing disability equality means placing emphasis on the dignity of persons with disabilities, striving to reduce or eliminate barriers while pursuing sustainable social change, and viewing persons with disabilities as right holders who, A, merit the redress of socioeconomic disadvantage, as well as appropriate recognition in order to combat stigma and stereotyping, and B, as individuals who have the opportunity to avail themselves of both participation in society and reasonable accommodation, where universal design attempts to provide this participation are non-existent or inadequate. So having completed the snapshot of my personal story of disability and provided some foundational ideas about the concept of disability equality, let me turn now to share an overview of two studies in the socioeconomic areas of transportation and post-secondary education. These two studies illustrate not only some of the major challenges faced by persons with disabilities in these contexts, but also the reasons why the tools of adjudication and standard setting are limited in their ability to successfully bring about disability equality and ultimately inclusion. So, with respect to the transportation inequality cases, I'll start by saying that from my earliest days as a person with disability, I found both extremely perplexing, if not frustrating, transportation issues that was faced by persons with disabilities. It was a collective issue. I knew from speaking with others that this was not just something that affected me, it affected many in the community. My frustration and then curiosity about travel barriers faced by persons with disabilities led me to conduct a research study about equality law and thinking about how equality law in theory could connect more productively with the rights of persons with disabilities in relation to transportation and better reflect transportation needs. The study that I'm going to talk about reviewed all the transportation cases before human rights tribunals across the country between 1976 and 2016, a 40-year period. In this study, my research assistants and I identified and focused on cases dealing with allegations of disability discrimination in the provision of transportation services. Statutory human rights bodies were chosen because human rights tribunals are designed to be accessible by self-represented litigants. Many individuals, therefore, present before human rights tribunals by expressing themselves directly instead of through the filter of legalized vocabulary of a legal advocate. These cases, therefore, often provide a window into what persons with disabilities are seeking in their own words, and oftentimes their own words are reproduced in the decisions themselves. The decisions reveal interesting facts regarding the reasons why these cases, and cases in general that use human rights codes to pursue equality, have met with limited success. And a review of the cases in the study sample show that the cases fall into at least three major categories. The first is cases where a person with a disability sought transportation restructuring. So the idea, the common reason for such a request was in response to the demands of advanced booking on specialized transit without guarantee of securing rides. A second category were cases where transportation was sought to provide a broader, provide support to a broader dynamic. This dynamic was often a family dynamic or a dynamic of social inclusion. And the third category of case comprised decisions where there was concern that a claimant's transportation needs had not been met. The needs could be related to safety, for example. In such cases, there was also usually concern that the transportation needs of the disabled person were not met because of a competing interest on the part of the service provider to preserve the efficiencies and expectations of the mainstream population using the transportation system. In addition, interviews conducted during qualitative fieldwork, related qualitative fieldwork, have confirmed how pervasive these barriers are. For example, one interviewee in Northern Canada discussed with me the challenges that they face in obtaining transportation and how the lack of transportation leads to obtaining, to being removed from contributing to society. So for example, this person spoke to me about how not being able to attend municipal meetings that were in the evening because of lack of transportation led to the voices of persons with disabilities not being included in municipal restructuring. And so additional compounded barriers, flowed from that. But returning to the study of human rights tribunal decisions, when it came to findings of discrimination, the cases were largely unsuccessful. Cases in which individuals sought transportation restructuring were largely met by jurisdictional responses, with the tribunal indicating that it was outside of its jurisdiction to, and its authority just generally, to engage in legislative reform or the kind of change that was being sought. Where transportation was sought to support a broader dynamic, such as family dynamic or social inclusion, when it came to family dynamics, to choose one of them, such as child rearing, the factual and legal analysis of the information presented often led to interpretations which put those child rearing obligations, family obligations, back within the private family sphere, instead of the public transportation system supporting in any way. And finally, where individuals alleged that their transportation needs were not met, such as wheelchairs not being tied down, individuals being placed on in places in a community bus, for example, where they felt less secure, there were disturbing and often unpredictable results that emerged, and evidence to show medical diagnoses, as opposed to barriers to travel, were common amongst the responses. Overall, what we learned from the study is that persons with disabilities were looking for more than what's offered by the two dominant theories of equality. These dominant theories are proper recognition of individuals in order to preserve human dignity and fair distribution of public goods and services to ensure all demographics and populations are taken into account. But the cases in the study showed us that persons with disabilities sought more than simply recognition or redistribution. They were looking, they were not really looking for just reasonable accommodation. What they seemed to be looking for was first order equality. In other words, a system that acknowledged their experiences and the barriers that they often and routinely faced during these experiences. They wanted a system that acknowledged these experiences and barriers from the get-go. And they also wanted their time to be respected in the same way that members of mainstream society had their time respected during transportation. Okay, so how do you address such concerns? That's the question that leads out of the study. And the concerns that are evident are not easily picked up in the discrimination analysis. I can give you two responses. One is that on a general level, it might be helpful to understand the purpose of the human rights statutes as undertaking a project of inclusion. If this idea underlies efforts of statutory interpretation within the anti-discrimination realm, then it may prompt adjudicators to consider the results that they reach in light of this overall goal. Another, more specific or precise intervention could be made in the form of a rebuttable presumption. Specifically, within the first part of the discrimination analysis, in Canadian statutory human rights law, a claimant needs to show that there is a prima facie case of discrimination. A very challenging part of this test for claimants is the requirement, claimants who are persons with disabilities, is the requirement that they must demonstrate some sort of nexus between the adverse impact that they've experienced and their protected ground. A rebuttable presumption of the existence of this nexus may help to acknowledge the barriers that are often and routinely faced by persons with disabilities. It could also assist claimants to make their case, given the power and knowledge imbalance that exists between a service provider and the person with a disability. In other words, it's difficult for an individual to know how these decisions are being made that result in an adverse impact within the respondent's working context. I'm going to move on from there. I will just say one more thing, which is that many cases in the entire sample were dismissed at a preliminary stage. And so in terms of the legal guidance that one would hope to glean from the cases themselves, it was difficult to get that information. So adjudication over transportation inequality by human rights tribunals has therefore not shown us a terrible amount of progress for achieving disability equality and social inclusion. What about education, and particularly post-secondary education? On the CRPD committee, I've often asked government delegations from different countries about their mechanisms or plans for addressing barriers for post-secondary education. Part of the reason that I ask this question is because it's important to have students with disabilities at the post-secondary level in order for them to engage in leadership roles later on in society. These voices can have important contributions to society. And without the opportunity of reasonable accommodation and other educational opportunities, they may not exist or emerge. Article 24.1 of the CRPD provides a commitment to the full development of human potential and of a student's sense of dignity and self-worth, as well as a commitment to develop the student's personality, talents, and creativity, along with their mental and physical abilities to their fullest potential. Article 24.5 builds on this commitment by guaranteeing persons with disabilities access to general post-secondary or tertiary education, vocational training, adult education, and lifelong learning without discrimination on an equal basis with others. Nevertheless, on the ground, within educational institutions, we know that disabled post-secondary students continue to face barriers to education every day. And I've just included in this slide deck a quote from General Comment number 4 of the CRPD committee dealing with inclusive education. that reads that inclusion requires an in-depth transformation of educational systems in legislation, policy, and the mechanisms for financing, administering, designing, delivering, and monitoring education. A few years after the study on transportation, I completed a study that looks at the barriers experienced by post-secondary students with disabilities in Canada. The two studies are similar in the sense that they both examine human rights tribunal decisions. However, the post-secondary education study examines as well a new post-secondary education standard for persons with disabilities that was developed in Ontario in 2022. It's also smaller in scope. So first of all, which jurisdictions were in the study? The jurisdictions that were chosen were those that had a consistently high percentage of disability discrimination claims in the years around the time that the study was conducted. So the provinces of British Columbia, Manitoba, Ontario, and Saskatchewan were included along with the federal level. I've provided a bit of disaggregated data to the extent that we were able to extract from the material that we collected, the cases that we collected. And you can see that the largest percentage of cases were cases that dealt with mental health related disabilities. There were also cases dealing with learning disabilities, physical disabilities, and the remainder of the cases were cases where it was not possible to identify from the material, the submissions made by the parties, what the disabilities were. So a basket of mental disabilities is the expression that was used, in which it wasn't specified whether the mental disabilities were intellectual, psychosocial, neurodiversity, etc. And another group where the disabilities were of a mixed type or unspecified. We were only able to pull what was reported in the cases, and so we didn't have additional information. In terms of the barriers encountered, though, there are three principal barriers that emerged from the research and data analysis. The first is admissions barriers, and there's 22% of all cases that dealt with admission to post-secondary education. We have updated this data to 2025 and found that this 22% remains steady. The next category that we found were barriers to in-program accommodations. So for those students seeking accommodations such as changes to evaluations, extensions of time, things like that. Barriers to in-program accommodations comprised 72% of the sample. The final category is a category that we've termed living barriers. So these are barriers that affect students with disabilities in contexts such as, their housing, things like that. It was an unexpected category that emerged. In addition to these barriers, looking across the entire sample, there was another category that intersects. 50% of those students who encountered barriers of any of the three categories that we had before also encountered legal barriers. And by legal barriers, I'm referring to barriers relating to procedure and to bringing forward their own case. And I should mention here that 50% of all of the cases brought forward were also brought forward by self-represented litigants, so by the students themselves. And I placed an image of a red rope fence here to suggest that we should stop and think about the intersecting barriers that arise for students with disabilities with respect to the core of post-secondary education, as well as the advocacy or lawyering type skills that they need to pursue a remedy. So in the time remaining, I'd like to talk briefly about the nature of these barriers and about the post-secondary education accessibility standards that were introduced or developed, I should say, in Ontario. And then move to some remarks on disability as an ethical project of inclusion. So starting with admissions barriers, in the case law analyzed during the period studied, admissions barriers decisions primarily dealt with requests for accommodations in the taking of standardized entrance exams or in the way that admissions criteria were evaluated. One case in the study also concerned funding, and although there was only one case, it was quite significant. As I mentioned earlier, human rights decisions regarding barriers on the admissions process are emerging. 22% is where they're remaining at the moment. And within that subset, within that 22% of cases, there's also a small but notable number of decisions relating to accommodations in standardized entrance exams. These cases tend to show that it's usually because of a profession's dominant belief in the accuracy of standardized tests, that in some fields, alternatives to writing a principal entrance exam are not readily available. There are a number of questions that, after going through the sample, have emerged, and I've highlighted them on this slide. So there are questions such as, what are the factors that should guide the granting of accommodations to standardized testing? In what circumstances could a testing center be successfully challenged for having requested a surplus of diagnostic assessments or be deemed to have relied on an incorrect opinion by its experts regarding the sufficiency of accommodation? How best can the perceived value of standardized testing for professions be addressed? And these are questions that I think are some of the leading questions that are very, very much pertinent even today, and that the jurisprudence is still somewhat grappling with. We need some strong kind of test cases, in my opinion, in order to really get to the heart of this, to have fully developed legal analyses. At this stage, especially since in a sample such as this one, you find that 50% are brought by self-represented litigants who are where the decision is often dismissed preliminarily. We don't have the answers to these questions in a way that would be most helpful. Oh, sorry, before I move on to the next set of barriers, one other thing I did want to say, though, is that there is one case in Ontario that has given us significant guidance, the Longape case. This is a case about an individual who had applied to university after leaving university at an earlier stage in their life. And when they were at university at the earlier stage, they were unable to have their, they did not have accommodations for the disabilities that they had. In fact, at that time, they didn't realize that they had disabilities. This case has made its way to the Ontario Court of Appeal, and there are some really kind of interesting strands that come out of that decision. So, for example, the latest decision in this series has indicated that the university in question should test out a previous learning assessment recognition module or pilot project based on PLAR, so previous learning assessment recognition principles that are used have been used in the province by another university. They're to check in again with the Human Rights Tribunal with respect to how well this works and what they've done. And so there are some steps that are being made and some avenues that we see, even if we don't have the full picture yet. This is an area that's emerging. So barriers to in-program accommodations. I'll say here briefly that some of the lessons learned here reveal that it's necessary for students to ask for accommodations at the earliest opportunity possible. The guidance that we have that's available also emphasizes the importance of students connecting their disability firmly to the supports that they request. Cases on in-program accommodations barriers also, interestingly, indicate that there are students who would prefer not to reveal their disability and protect their privacy for fear of stigma and really struggle with how to do that. And so there are a couple of very interesting cases that demonstrate the struggle and, lead us to reflect on how it might be addressed on the ground. I have mentioned legal barriers before, and essentially what I'm referring to here are procedural barriers that students with disabilities who are self-represented face. Many of them deal with issues such as timeliness, so being able to bring a matter forward, which itself incorporates the question of whether it's necessary to wait for all of internal university processes to be exhausted before going to, say, a human rights tribunal. So there's a lot of kind of confusion on the ground in terms of what it is that needs to be done, especially if you're a self-represented student litigant. And this really just kind of brings us back to the idea of complaint mechanisms needing to be clear and explained to the students who use them. So I'd mentioned that I would also say a few words on the accessibility standards for post-secondary education in Ontario. Ontario is the only province to date that has developed recommendations for post-secondary education, a standard of post-secondary education. The final recommendations for this standard were released in April 2022. So under the governing legislation for these standards, which is the Accessibility for Ontarians with Disabilities Act, recommendations are released after going through public consultation and modification, and then they become binding after ministerial approval. While the concrete recommendations in Ontario are quite numerous, they're wide-ranging as well. I'll mention just some of the more innovative recommendations. So the Education Standard Development Committee suggested instituting metrics to measure progress on accessibility, measuring and improving campus climate, and making inclusive and accessible pedagogy an evaluative criterion for teaching awards and research grants. There were other things that they suggested, such as requiring student unions to, this is a quote, support student access and participation in non-academic campus life by funding accessibility support, such as sign language interpreters and attendant services. Educators, librarians, and members of the administration and leadership are also required to receive training every 3 years on their obligations under the Human Rights Code and the standards that have been created. There's also an explicit recognition of intersectionality, placing the lived experience of students with disabilities and their intersecting identities, this is a quote, at the forefront of its work. And so there are many dimensions to this. So how are things going with the accessibility standards for post-secondary education in Ontario? Well, unfortunately, the government has not actually approved this. It's been waiting for approval for quite some time. I'd mentioned since 2022. They've essentially been left in a state of limbo. And this is definitely one of the risks of using this process. However, some Ontario universities nonetheless have gone ahead with implementing what was suggested in the final recommendations. And I think the approach that they are taking is one that fits quite neatly with the theory that I've termed disability equality as an ethical project of inclusion. So let me move to the last part of my presentation to talk about this theory. So what is disability equality as an ethical project of inclusion? And I'll say from the outset that by ethics, I do not mean relying on the ethical leanings of those who are at the table at any given initiative of law reform. The project has to be more structured exercise with that than that, and one that relies less on situational circumstances. In this context, I'm using ethics to mean a set of principles that guide our conduct. We often think of the terrains on which we aim to secure disability equality as battlegrounds. You know, the most evident is in the context of adjudication or litigation. But this idea also occurs in situations of creating accessibility standards. So this is because the standard development process itself is one where consensus is often sought after debate amongst individuals from the disability community, industry, and government. However, I want to suggest that it may be more accurate to consider disability equality also as an ethical project of inclusion. And what this means is that elements drawn from the theory of disability equality, such as ensuring the dignity of persons with disabilities, pursuing resource allocation to redress socioeconomic disadvantage, ensuring appropriate recognition of persons with disabilities in order to combat stigma and stereotyping, along with the other elements of the human rights model of disability and inclusive equality, should be considered in all reactive and proactive law and policy making affecting disability equality. I would suggest that there are three broad pillars to this conceptual approach. First, disability inclusion should form an overarching goal and a leading light in the interpretation of human rights law and disability discrimination cases. This would include a reminder of the disability equality elements in litigation facta, in training for judges and adjudicators, as well as any other context in which efforts to improve disability equality initiated by government, disability advocates, etc., exist. The second pillar is that legislative directions and rebuttable presumptions favoring disability equality can be used wherever that's possible. So with respect to legislative directions, if created properly within statutory preambles or other statutory text, they could reinforce the elements of disability equality theory, assisting with the interpretation of statutes in ways that further disability inclusion. With respect to rebuttable presumptions, I've discussed this earlier in relation to the example of their potential use in human rights adjudication over disability discrimination cases, where I'd indicated that they might help to address both power and knowledge imbalances and to recognize some of the routine barriers that persons with disabilities face. The third broad pillar deals with roles and responsibilities. The roles and responsibilities of those who are involved in any project designed to advance disability equality. I say this often in the context of administrative justice, that those who are at the helm have a responsibility to promote and further the goals of their statute. And when it comes to disability equality and disability equality contexts, statutory contexts, it would be useful to make sure that all those involved fulfill their responsibility to make sure that the project is successful. So I'll end by saying that I realize much more theorizing could be done. At the moment, what I'm presenting are some ideas about what an ethic could look like and how it might be used. But I envision disability equality as an ethical project of inclusion, as a contribution, an approach to addressing issues affecting disability equality. It's not meant to be a complete solution, but I believe that one of the steps to more effective dialogue, litigation, and policymaking in the context of disability equality is to have a deeper understanding of the barriers faced by persons with disabilities and a more active role for the public interest. So with this, I conclude my remarks with thanks. And I thank you for your attention and for the honor of delivering this year's Owen Lecture. I look forward to your questions and your comments, and I thank, of course, all of you, Allard Law, for supporting this. So thank you.